introduction, and thanks so much for having me. This webinar was extremely well timed, almost too well timed. We'll be presenting the results of a recently published study on the NEPA process, and particularly on litigation for large infrastructure projects in the United States. The study, we completed it over the summer. It's actually being published on, I think, Monday. There is a preprint available on our website currently, and I'll provide a link to that in just a sec. So very timely. We didn't, that wasn't intentional, but it happens to be good timing for this study. So just a little to build on the introduction from earlier. So my name is Mike Bennon. I manage a public policy research initiative on global infrastructure policy at Stanford. It's within our Freeman Spogli Institute, which is our public policy and international studies institute at the university. Today's study is really focused on the permitting process for large infrastructure projects in the United States. But we also do a lot of research on projects outside of the United States as well, and topics ranging from public-private partnerships to global infrastructure finance, multilateral finance of infrastructure as well. So that's just a little background on my research program at the university. I'm also part of the Build America Center, which is hosting this webinar. So as many of you are probably familiar with the Build America Center, but we do research and education on project finance and public-private partnerships and many other topics relevant to public sector officials in the transportation sector in the United States. So it's hosted at the University of Maryland. And if you're not familiar with the BAC and all the research that they've put out and some of the training programs that they've put on, definitely check them out as well. Interestingly enough, so as my next research project with the Build America Center is going to be a study of kind of renegotiation and conflict resolution on large public-private partnerships. Part of that is a case study on the Purple Line in Maryland. So that's our next big project with the Build America Center. I only mentioned that relatedly because one of the issues that came up for the Purple Line was NEPA litigation and how the public sponsor and the concessionaire kind of sorted out some of the issues associated with that. So that's just a little bit of background on me. So as I mentioned, this study is kind of a preprint's available now. The published version will be out on, I think, on Monday or Tuesday next week. It's in the Environmental Law Reporter. And I'll be giving a little bit of an overview today of some of our findings and some background on NEPA. I assume some folks on the webinar are pretty familiar with, at least at a high level, the NEPA process and how it affects large projects. But I'll be giving a little bit of an overview before I dive into our study. Great. So first, I just have a couple of slides to talk about the NEPA process and kind of give a little bit of background as to why we did this study and why I think it's an important topic for further research as well. So the National Environmental Policy Act, or NEPA, is a real foundational law of kind of environmental regulation in the United States and even globally. It was passed in 1970, and the NEPA process is, I say it's globally important because it's really served as the basis for a lot of other environmental regulations in other countries outside the United States, and even in kind of multilateral institutions, multilateral environmental safeguard programs have kind of incorporated the principles of NEPA as kind of the basis for how they evaluate projects environmentally. In fact, in the environmental law industry or in environmental law practice, they call NEPA the Magna Carta of environmental law. So it's an extremely important procedural law on environmental regulation. And for folks in the project development industry, you probably have a rough idea of the NEPA process, in that it's what produces the big environmental study, right? So when a project needs to be built, there needs to be an environmental study. NEPA is the law that establishes that procedure. So that's kind of how we associate it in the project development world, is with the big environmental study and community consultation process that has to be done before you can undertake a large project. That's how we what most people think about NEPA is that kind of administrative process that an agency has to complete. I would maybe adjust that a little bit to point out that NEPA is also a democratic process, in that agencies have to complete a study. They don't just implement the study, they have to then publish the study to the public and take input from the public, and most of us are familiar with kind of community consultation meetings, written public comments on an environmental study. There's an opportunity for public input that's mandated by case law. And then there's also a judicial process over NEPA. That stakeholders and individuals can challenge environmental permits under NEPA in federal court. And I'll talk about how that works later on, because that was kind of the main area of this study. But this kind of administrative, this democratic and judicial process is kind of why NEPA is understood as one of the kind of foundational laws of the administrative state and how the federal government functions. So this is an extremely important procedural law. So the law as written is pretty general. It requires federal agencies to produce a statement, which I'll talk about in a few minutes, and summarize their findings as to the environmental impacts of a project. It also created an organization called the Council on Environmental Quality in the White House, or the CEQ. And the CEQ is basically a small agency that puts out guidance to the other federal agencies about how to implement NEPA, how to do an environmental study. So that's one way in which NEPA can evolve, is through the guidance from the CEQ. And then the other way in which it evolves is through case law. So when a court rules on that an environmental study was inadequate for some reason, that creates case precedent that impacts future projects potentially. So NEPA has kind of been an evolving law since it was passed about 53 years ago. And some of there's been a few issues that kind of come up that are kind of regular issues in the NEPA process. So it's kind of what level of study is required. That's actually the most common cause of litigation, is kind of the level of study that's required and disagreement over that. I'll talk about that in a second. But other issues in terms of NEPA litigation, NEPA requires agencies to study alternatives to the project. So if the project is maybe it's in transportation, it might be a light rail line, or maybe it's adding a lane to a freeway. The agency will have to look at different alternatives to that project, and that's also a subject of litigation. In that, have they studied all the necessary alternatives? It's kind of a little bit open-ended. There's kind of an infinite number of potential alternatives to a project. So when have we kind of studied enough alternatives? And then the impacts of a project. NEPA requires agencies to study the impacts of a project. Well, what's the stopping point of that? Is it kind of the direct impacts of a project? But all projects also have cumulative impacts with, combined with other projects. They have indirect impacts. So kind of, that's another kind of question that sometimes is the subject of litigation, in that agencies haven't studied enough impacts. And then also, another issue is kind of how new information should be incorporated. So that's a little bit. I probably should have mentioned, just as a caveat. I know I'm spending just a few minutes giving the kind of NEPA 101 here. I am not by no means completely describing the NEPA process. I'm just trying to give an overview. This is a very complex administrative process. There's lots of nuance in the types of studies and other issues. So I'm trying to give a high level here, and I'm sure I'm glossing over a lot of detail. So in terms of that process, and again, this is for the material that's relevant to our study. First, maybe I'll just mention some of the types of study for NEPA. There's three basic types of NEPA study. The first is a categorical exclusion. So this is for a type of project that is either excluded from the NEPA process by statute or by agency regulation, has determined that this type of project isn't going to affect the environment. That's essentially what a categorical exclusion is. So in that case, an agency will complete a CE, or categorical exclusion. You can think of this as a pretty minor bureaucratic exercise. There is variation in how long they take, and they can be challenged in court too, but there's evidence that they're challenged a little bit less in court, and they don't take very long. So it's a kind of a minor bureaucratic hurdle is a way to think of these. It's also the vast majority of federal projects fall under CEs. So upwards of 95, maybe even 98+% of all federal actions, of all environmental permits under NEPA, are CEs. So this is the vast majority of things, are kind of very small projects that aren't going to affect the environment. On the other end of that spectrum is the environmental impact statement, or the EIS. That's for the big project or big federal action that is going to affect the environment. That's what most people, when they think of NEPA, they think of the big environmental study. That's an EIS. And so that applies to a very small percentage of actual projects. That's also the subject of our study today. So I'll introduce our study in a minute. But we're studying EISs, so the big projects that are affecting the environment and that do require a big environmental study. There's also an environmental assessment, and that's for kind of in between, when you're not sure if a project needs an EIS or not, as well. And then the last thing I'll mention is that there is such a thing as a supplementary EIS. That's completed when an agency concludes that it needs to do more environmental study. Let's say it's already completed an EIS for a project and they need to do some more. So what's the EIS process look like? Well, when an agency needs to do an EIS, they'll first publish a notice of intent. They're gonna do this environmental study. They'll draft the study and publish the draft. They will then accept public comments, go through the consultation, and they'll publish a final version of the study that's supposed to incorporate that public input. And then the NEPA process ends when they publish a record of decision. And that's when they say, okay, we've made a decision on the project. So those 4 steps are relevant because that contributes to our data set. So the data set that we use, this is the full CEQ data set, but our study is based on a data set that was published by the Council on Environmental Quality that has that information. So we have the dates of when they started the NEPA process, when they drafted the environmental permit, when they finalized the study, and then when they actually made the decision. This chart is the study I'm going to be talking about today is based on a subset of this data set that's for large infrastructure projects. The chart that I'm showing here is the full data set. The CEQ collected data on environmental studies that were completed between 2010 and 2018. And what this chart shows is the date of the record of decision on the x-axis, so when the permit or study was completed, and then the y-axis is the number of years that the study took. So some variation, some pretty big outliers there. Most of the permits are taking under 5 years. And again, this is not just for infrastructure. This is for all federal permits. So that's kind of the procedural 101. Okay. So what we wanted to look at was the subset of those projects or of those environmental permits that applied to large energy or large transportation projects, and and compare project outcomes. So was the project built? Project characteristics, what sector is it in? And some other characteristics. Permit characteristics, how long did the permit take? Did they do a supplementary study? Was it on the permitting dashboard? There's a federal permit dashboard. And then litigation. So was there litigation associated with that environmental permit or otherwise during the pre-development process? That's what we wanted to do. We wanted to basically kind of cross-compare those 4 characteristics, about the permit, the project, the litigation, and then the outcomes of the project. And believe it or not, that hasn't been done before, in part because there hasn't been a great data set to compare across those issues. And I'll talk a little bit about, in terms of transparency within the industry, on why it was so difficult to do this study, even though our data set, the full CEQ data set, was only about 1,300 environmental studies. And our data set's less than 400 infrastructure projects were permitted through an EIS during that period. And it was still very difficult to compare data across those different verticals. So that's kind of speaks to one of the reasons why we wanted to do this study. It's very difficult to appraise the costs and benefits of the NEPA process. So we kind of have a broad idea that the NEPA process does obviously creates delays for large projects. They have to do the study. It's really hard to appraise the costs of those delays. It's difficult to appraise the cost of litigation because yes, there's lawyers, obviously, there's environmental consultants to write the studies. Those are costs. But I would argue that those are actually probably a very small percentage of the costs, of the broader costs of the process. Most of the costs are probably associated with delays or uncertainty in the project development process, but most of those costs are very indirect. It's very similar to the appraisal of the environmental benefits of NEPA. We have a pretty good idea, and we discussed this in the paper at length, that the NEPA process has improved the environment. The idea is that if federal agencies are required to, look before they leap and do a detailed study before they build something or take another action, that, on the margin, they're going to take more or less environmentally impact actions. And, we've seen, since NEPA was passed in 1970, there's a whole host of environmental metrics in the US, like air quality, water quality, these other issues that have improved. So we kind of know that NEPA's helped improve the environment in some way, though we can't really kind of trace that because a lot of it's indirect. That's my point. And the other thing that I would add there is we by no means have kind of solved this question. And in fact, one of the conclusions of our study is that we're not going to get there, in terms of we're not going to ever be at a point where we can say, okay, these are the pros of NEPA, these are the cons of NEPA, and like do that quantitative analysis because there's so many indirect impacts of a law like NEPA. But even given that, there is still a lot of uncertainty, a lot of difference. And that goes to my second bullet here. There's just a wide range of conclusions. If you read some of the studies that are out there on the NEPA process, some of these studies are saying that there's huge costs associated with the NEPA process. Other studies kind of conclude that, hey, this is really impacting a very small number of permits, especially litigation. There, if you look at all permits under NEPA, a very small percentage are actually litigated. If you look at all of the permits, including all those categorical exclusions, which are 95, 98% of permits. So, there's just wide variation in studies, and it's part of it because all these studies are descriptive. This study is descriptive. We compare. We have a limited data set, and we're comparing characteristics across projects. You're never going to get a final conclusion on some of these topics. As I mentioned before, there hasn't been a prior direct empirical study of litigation on these projects. So there have been a few studies that have kind of compared at a high level litigation. So they might look at kind of litigation associated with Forest Service projects and permits associated with the Forest Service, and do some comparisons that way. But in terms of kind of trying to really map projects and permits to litigation, which is not as easy as it sounds, that is the exercise that we wanted to undertake here. And I mentioned the Forest Service just a second ago. So the other reason why we were interested in this topic is that most prior study of the NEPA process has been pretty concentrated on either the Forest Service or maybe the Bureau of Land Management, the federal agencies that manage huge parts of federal land. And there's a reason that most of the studies have concentrated on those agencies. One is that they do most NEPA. So, if you look at the number of permits, they do a lot of permits to manage federal land. And these are really important environmental studies of endangered species, land management plans, you name it. Forest management is a huge one. The Forest Service produces more environmental studies than any other agency, and it attracts more litigation than any other agency. So because of that, they collect a lot of data on the permitting process. And because of that, there's been more study of the Forest Service or maybe Bureau of Land Management, and more studies of litigation in the Forest Service and land management. And that's great. But it's also the environmental permitting process and litigation we thought might affect infrastructure projects differently than a land management plan. And also the environmental issues associated with the infrastructure were different. So we wanted to do a study of infrastructure specifically, separate from area management, even though that's a very important area of study as well. And the other thing I would mention, just as kind of like an aside on this topic, is that a lot of environmental law has also been kind of forged through the Forest Service litigation, Bureau of Land Management. These area management plans have been, a lot of case precedent has been on these types of projects. They attract a lot of litigation because they're so environmentally important. And so, you have a little bit of a process that's kind of been focused on the litigation side on area management, also affecting infrastructure in a big way. So that's kind of another nuance. I mentioned some of the challenges linking between those verticals. And then also, public interest. Obviously, this is a really important topic, and it's gotten more important recently. So if you followed the news over the last year on permitting, it's been a pretty big topic. Federally, last year, Senator Manchin had floated some permitting reform proposals. They were not. There wasn't any legislation that came out of late last year. However, there was some recent changes to NEPA permitting that were passed in the debt ceiling deal earlier this summer. So that's kind of the most recent permitting reform. They're still talking about permitting reform in Congress. There were some big changes to guidance by the CEQ during the Trump administration, and there were more kind of quasi reversing those changes through the Biden administration, through guidance. So there's been big changes to NEPA guidance recently, and it's become a pretty salient topic. The only thing I would really add there is that probably most of the most of the changes that have been floated and made during in these reforms, including the debt ceiling deal, were kind of administrative reforms as opposed to direct changes to litigation, though there were some. But maybe we can talk about that during the Q&A. So just very briefly, I'm not going to go into NEPA law and case law in a ton of detail here. I'll kind of jump into our study results in just a minute. But there were just a couple of salient things that I wanted to mention about NEPA, the law, and then some of the important cases for just a minute. So, there's two really important sections of NEPA when it was passed in 1970. Section 101 of NEPA includes some substantive requirements of the law. And I included a few quotes here, but things about kind of broad goals about protecting the environment, assuring that all Americans have a safe, healthful, productive, and culturally pleasing surroundings, those kinds of statements. Now, Section 2 includes the procedural requirements of NEPA in terms of that an agency will produce a statement of findings on the environment. Now, it doesn't include a lot of detail. It's mostly been developed through case law. The reason I highlight this is important for our study is that, and I'll just build the slide, there were some really important early cases that kind of really set NEPA on its current path. I mentioned a couple of them here. And one of the important aspects of these cases is that courts treated these two sections of NEPA differently. So when litigation over NEPA first came to the judiciary, courts looked at Section 101 and kind of said, okay, we're going to kind of defer to federal agencies on that. These are just broad goals that are kind of, a previous author said they were framed in lofty generalities, right? So these are broad goals. We're not going to, intervene in a permit because we think it doesn't achieve a balance between population growth and resource use. But the procedural requirements of NEPA, now there, courts said, okay, we will maybe intervene if we feel like a permit hasn't procedurally met the requirements of the law, i.e., have they studied enough impacts? Have they studied enough alternatives? The courts have intervened on those grounds. And that kind of set NEPA on a path of development in the judiciary, is what we argue. That's very procedurally oriented. So generally, if stakeholders litigate against a permit, courts are pretty deferential to agencies on substantive matters. So if an agency has an estimate of, an environmental impact, like the amount of GHG emissions, just take, for example, courts won't necessarily jump in and say, no, I think your estimate of GHG emissions is wrong. Go redo the permit. On procedural matters, they have been less deferential. So when there's, say, an impact that wasn't studied, and the court thinks maybe that impact should have been studied more, they might enjoin the permit. And that's the remedy. They'll enjoin the permit and say, hey, you have to go back and do additional environmental study and stop the project. And that's obviously a big deal for the agencies or sponsors of the project if the project's enjoined. So there were a few cases that kind of started this path. The Calvert Cliffs and Gillam Dam are the ones I mentioned. They have set a lot of precedent, but they established kind of a narrow judicial review for NEPA. So these are just a couple of other topics relevant to the study before I jump in on the next slide. the one maybe I'll mention is this topic of litigation proofing. So this, and we didn't coin that term. It's been in kind of NEPA circles for some time. And basically what litigation proofing refers to, and this is really what we were aiming to study, was when a federal agency gets that when there's a conflict over a permit, and an agency is worried, maybe there's some comments or otherwise they know there's a potential for litigation over their environmental permit, they're faced with a difficult question. That is, do we keep studying the project in order to litigation proof, study more issues? Because again, where they're more vulnerable to injunctions is procedural. Did we study enough? Or do they finalize the permit and take the risk that it'll come up in litigation and then a court will say, no, you should have studied X, Y, or Z? That's this issue of litigation proofing. So, some of you have either seen or maybe even worked on environmental studies that are many thousands of pages long, far longer than anyone could read. Some of these studies get into the tens of thousands of pages for contentious projects. That, we argue, is probably a sign of litigation proofing. And so that's something that we wanted to study. Does that work? If you litigation proof, if a permit takes longer, maybe even is longer in terms of number of pages, are you less likely to be litigated or enjoined? That's one issue. And then the other thing I mentioned, this arbitrary and capricious, that's kind of the legal standard that was accepted. Courts shouldn't intervene unless it's an arbitrary or a capricious, unless that's their determination. So Mike, now I'll just jump in. Yeah. Oh, go ahead.
Mike, so there's I think a quick question that you could probably answer. Is there a statute of limitations to file litigation over NEPA on a project?
Yes, there is. I don't know offhand, because actually the statute of limitations has been a subject that's come up in recent reform proposals of maybe even shrinking that. There is a basically after the record of decision, so after the permit's done, there is a statute of limitations where you have to file litigation challenging the permit in a certain time period after the ROD. So there is one. I don't want to give a number. It might be 6 months or maybe even 90 days. I'm not sure. So, but there is one to answer that question. Yeah, it's a good question. So just driving ahead to discuss our data set briefly. I've already discussed this in a little bit. So our data set consists of 355 projects. All of them completed a final EIS between 2010 and 2018. It's based on a data set collected by the CEQ. We supplemented it. So we coded projects based on their subsector. We looked for litigation on the projects. And we didn't code the litigation in a lot of detail, but we did code litigation based on whether it was associated with NEPA, whether there was a claim under NEPA. And oftentimes on litigation against a permit, there might be multiple claims. So they might have a NEPA claim, maybe under the Endangered Species Act, there'll be a claim, other issues. But that's what we wanted to examine. So we kind of at a high level coded it. And then we had some other data as well, like the agency, how long the permit took, and the current status of the project. So that's our data set. Just very briefly, just to discuss kind of what we're looking at. So what did the federal government do between 2010 and 2018 is an interesting kind of finding as well. These are of the transportation projects. Clearly highway projects are the majority of the permits that were complete, again, for EIS projects. These are big projects that will affect the environment. More than half of the studies completed during this period were highways. Most of those we interpreted as highway improvement projects. meaning maybe it's rebuilding an interchange or maybe even adding some capacity to a highway as opposed to a new highway. Light rail transit was another big sector within transportation. Within energy, transmission was a big sector in terms of the number. This is just number of permits. And I imagine that has even increased given the importance of transmission today. Again, these permits were for between 2010 and 2018. Solar projects, wind projects, pipelines are another big sector within energy as well. So the first finding, just to jump into some of our kind of results of the study. The first big finding is that roughly half of the projects in our data set were complete as of the time that we finished our study. So this would have been as like last fall when we were checking project status. That was kind of a surprising finding. So roughly a quarter of the projects are still under construction, and the remainder are either canceled or still in some form of planning or pre-development. So they haven't started construction. And that was kind of interesting because all of these projects had completed a final EIS. So the EIS was done sometime between 2010 and 2018, and only half of the projects exist at this point. So there's something else, right? Either budget issues, political changes, other permitting issues, state, local permitting that's delaying some projects. There's some indications of that. Also engineering considerations. Some projects, they take 5-10 years to build. So, that's a factor as well. This chart just shows the projects broken, color-coded a little bit by the date that the permit was completed. So you can kind of tell there is, on this chart, you can see, some of the projects that were completed earlier, where the final EIS was completed in like 2011, 2012, they're more likely to be completed. So there's maybe engineering considerations there. That was one result. Most of the litigation that we found associated with permits or pre-development for projects did include at least one NEPA claim. There was, about 10% of the litigation was either over some other federal law, not NEPA. There was maybe one or two FOIA claims, Endangered Species Act claims, otherwise. And then there were a small percentage that were just associated with a state environmental law rather than NEPA. And so then, I'll get to our kind of main findings and some recommendations here before opening it up to questions. So the first question that we wanted to look at was, does litigation proofing work? And our results here, and I'll show you two charts here. The first is over litigation. These are based by subsector of project. And then the second chart that I'm going to show you in a second is on project cancellation. So rates of project cancellation within the sectors. So does litigation proofing work? Our conclusion is kind of, but not really. In that, and that is kind of illustrated by this chart. So what this shows is the x-axis is the average duration of the EIS in the sector. And then the y-axis is the litigation rate. So overall, we observed a litigation rate across all these projects of around 28%, which is high. So around, less than a third of projects are associated with some form of litigation. That's high, but the other past studies have kind of broadly estimated that could be in the 20-30% range. So it's not out of the question. But we're seeing a trend here. between energy and transportation projects. Broadly speaking, energy projects have much shorter permit durations. They're finishing the studies faster, and they appear to be getting sued more. So not just solar, but pipeline projects, wind projects have a pretty high litigation rate. Transportation projects get sued far less, but they have extremely long permitting timelines. That's a more than 10-year permitting timeline for a new highway. So in other words, in transportation, we're seeing lots of litigation proofing. Longer permit durations it's indicative of that. Less so in energy. One thing I should probably mention in terms of something like permitting or wind projects, pipelines we're probably capturing a lot of. Solar shows a high rate of litigation. Part of the driver of that is that we are not capturing all solar projects. In fact, we're probably only capturing the solar projects that are most likely to get litigated. So that kind of explains that result a little bit. Most solar projects are privately developed, privately financed. If it's on private property, there's no federal involvement, it doesn't go through this process. The solar projects that we are capturing in our data set are probably very large solar projects, and they're probably sensitive in that they're either on federal land, they impact federal forests, they impact tribal lands. So you can probably tell we're kind of capturing a contentious subset of the solar project. That's actually of all solar projects. That's actually, I think, an interesting area for further study. But to the broader point, you're seeing less litigation, more litigation proofing in the transportation sectors. Similar result to cancellation. You're seeing shorter permits, more cancellation in some of the energy sectors, much longer permitting times, and lower rates of cancellation in transportation sector. So how we explain this result or what we attribute this to, is rates of private financing between the sectors. So many energy projects are associated with private developers, private financing, whereas highway projects are developed by transportation agencies or public agencies are going through the permitting process and driving that process. And so you're seeing different behavior in terms of litigation proofing when there's private development capital at risk in the project. The energy sectors where there is more private investment, there's more of a decision to say, no, we need to finalize this permit and move forward and accept more litigation risk. In transportation sectors, they're kind of permitting forever. They're litigation proofing forever is what this is an indicator of. And so, this has some implications. Probably one of our biggest findings is that maybe there's a little too much litigation proofing going on in the transportation sector, because when there's private development capital at risk, you're not seeing that same behavior. Now, it is kind of working to some extent, you could argue. There's less litigation in the transportation sector relative to the energy sectors. How much of that is explained by litigation proofing, we don't know, but there's at least indicatively, it's kind of working. In terms of overall development, maybe that's not a great thing. And just to indicate that, in our data sets, yes, solar, wind, pipelines have high cancellation rates, but they also have very high completion rates, in that most of the solar projects in our data set are either done and built or they're canceled. So they're kind of in the energy sector. The energy sector is kind of failing fast, if you will. In the transportation sectors, you see a lot more of these kind of zombie projects, that's my term, of like projects that have been permitted for decades. They're not canceled, but they're not built. They're still in pre-development. So that's kind of probably one of our biggest findings. Broadly speaking, just to mention a few others. So yes, we did see a correlation between litigation and project cancellation. Not too much of a surprise there. Another interesting correlation that we observed was there's a correlation between a supplemental EIS, doing an additional study, and litigation, meaning the supplemental EIS doesn't necessarily prevent the the litigation, and that's just more, we attribute that as more of just an indicator that those projects that are doing a supplemental EIS, there's a reason for that, that there's some conflict over the permit in the project, and there's still thus litigation over those projects. And then this is my last slide, so I'll open up for Q&A. Great, got about 10 minutes left for Q&A. Just a couple of broad takeaways. There's a lot more in the study that we discussed. We discussed some of the history of NEPA as well. We do discuss a lot of other studies that have been done. There's been a lot of empirical work on NEPA as well. The other thing that we discuss in the study is, broadly speaking, costs in the infrastructure development sector since NEPA became law. So, what indications do we have of real cost inflation in infrastructure, which is a very salient issue today. But we look at, broadly speaking, since the 1970s, how costs have changed in the sector. So that's a few other issues. In terms of, some of the results or kind of findings from the study, one is there could be more transparency over this process. In some ways, NEPA is extremely transparent. All these documents and studies need to be posted online. It's public meetings. In other ways, there's really not a lot of transparency, especially associated with litigation. Some decisions over projects and mitigations are made between the Office of Counsel at a federal agency. And it's a settlement negotiation over litigation, and these are really important kind of decisions, public policy decisions that are being made. So there could be some more transparency. We include some details on that in the study. We're not by no means claiming to have come up with some all costs and benefits of NEPA. By no means are we making that claim. It's too broad, and what we argue is we're never going to get there. This is a policy decision. We have to use the information that's kind of available. The one thing that we do point out is that the NEPA process, because at least in terms of litigation, it's naturally very oriented towards local impacts. And we argue that it is because the people locally directly impacted by the project are the plaintiffs. They're the ones that bring litigation against a project, or that are most motivated to bring litigation against a project. And courts in NEPA, because NEPA is procedural, a judge isn't necessarily going to look at a light rail project that has X, Y, and Z impacts locally, but that maybe has climate change benefits or all these other benefits. The process doesn't empower them to weigh those trade-offs. They have to look and examine whether the impacts were adequately studied. And that creates kind of a predilection that kind of, it's not, I wouldn't say biases the NEPA litigation process, but that's what drives outcomes. And then, the other thing, just in terms of private financing for P3s, the Build America Center, in some ways, private financing in the transportation sector is going through one permitting process that's very different than private financing in the energy sector in terms of that litigation proofing behavior. So that might be a relevant finding as well. And there were others, but I know there's some questions, so I want to leave a few minutes for that. So maybe we'll open it up. Mike, if it's okay, I can open up the chat, maybe just take a look if that's okay, or how is that the best way to kind of go through these?
So Mike, I've been kind of monitoring, so I think I can maybe lead this along, and if more questions come in, we can kind of catch them. So one question that was asked a little bit earlier, when you're looking at categorical exclusions, did do you know the breakout of, say, projects that are more on the things like recreation permits or concessionaire efforts versus things that are maybe over $5 million? Does your data look at that, I guess?
Yeah, we do not. There have been some studies of categorical exclusions, not necessarily breaking them down by type. As you can imagine, it wasn't easy to break down these less than 400 projects by type. Imagine doing that for 10,000. So no, we haven't looked at those issues. There have been some studies that have looked at categorical exclusions and kind of how long they take, whether they get litigated. I believe those have been limited to the Forest Service. The Forest Service collects excellent data on the NEPA process. So not so much in the energy sector. In terms of number of categorical exclusions and whether they're agency categorical exclusions or statutory categorical exclusions, I'm not sure offhand.
Okay.
It's a good question.
One general question is, could you just let folks know what database did you use for looking up the litigation status?
Yeah, we include so we used several databases to look up litigation. We also discussed some areas for future study, as I think there could be some more here. We used I believe Nexus Uni for some litigation, and then Westlaw as well. And we kind of checked between multiple. And there's a small section in the paper where we describe that in a little more detail. What we didn't get to, and what I think would be a ripe area for additional study, would be to actually code some of that litigation a little bit, maybe by type, some of the issues raised in the litigation. And then, what we did not code the result of the litigation. So we didn't code whether the project was enjoined, or whether the government kind of won the or settled the litigation. There have been some studies on that topic, very limited. Most of the studies that have been done on the actual litigation results and topics have been exhaustive case studies. So they'll take like one project, someone did the big dig in Boston where they actually went into all the weeds on some of the issues. Or the other studies that have been completed have been survey data, where they've surveyed agencies and said, okay, how many times did you get sued and how many did you win? And what were some of the issues? There was obvious issues with that methodology as well. So that would be a really cool area of further study. Yeah.
So folks, any other questions for Mike? Okay. Want to thank everybody for joining us today. Certainly want to thank Mike for giving us the presentation about the research that they've just really completed and are published. And so if you've got an interest in looking at the paper, I'm sure you can contact Mike, or I imagine we'll probably have it available from the Build America Center in some sort of way as well. So thanks again, Mike. Thanks everyone for joining us. Just a reminder, we're going to have another one of these webinars on October 27th, where Sasha Page of Rebel will come and talk to us a little bit about some of the work they've been doing, looking at development around arterials, in the transportation sector. So, again, thanks again for joining us, and hope you'll maybe think about coming back on October 27th.